Hi, my name is Marvin Cable. I'm an attorney in Massachusetts with a practice in marijuana-related law. Today, I'm here to talk to you about background suitability for operating marijuana businesses in Massachusetts. One of the most common questions I get asked is, how does my criminal background or negative history affect my ability to be involved with a marijuana-related business? But before I provide the answer to that question, some warnings. The final regulations are not out. This video is based on the draft regulations. The final regulations are expected to be out March 15th, 2018, and the making of this video is February 2018. In other words, everything in this video is subject to change. Secondly, this video does not constitute legal advice and should not be relied upon without consultation with competent legal counsel. And lastly, this video does not constitute an attorney-client relationship with any of its viewers. Before proceeding forward, I want to provide a breakdown of this video. I'm going to provide you some basics, some need-to-knows. Then I'm going to explain to you how the background check process works. Lastly, I'm going to go through what is and what is not allowed in a person's background. So, some basics. As you know, marijuana was legalized by the voters of Massachusetts in 2016. Because of this legalization, some regulations are to be promulgated and will be promulgated soon, as I mentioned, that provide the details as to how marijuana-related businesses should work in Massachusetts. The citation for that is 935 CMR 500. Essentially, the regulations provide all the details about how marijuana businesses should operate, including the suitability standards for people seeking to operate, own, or work with a marijuana-related business. Essentially, they establish the controls for a legal cannabis market. If you take a look at the slide here, you can see the titles for the different sections of the regulations. You can see that the regulations try to encompass the entire industry of marijuana-related businesses. But we are only concerned with the last four sections, that is 500, 900, all the way through to 500 and 903. They provide the suitability standard for licensure or registration as a marijuana establishment agent. I also want to provide a note. To understand the background check process, one should also understand the 8 different types of licenses available to people in Massachusetts. They are marijuana cultivator, craft marijuana cooperatives, marijuana product manufacturer, marijuana retailer, marijuana research facility, independent testing laboratory, marijuana transporter, and marijuana micro businesses. To fully understand background suitability, one must understand or be vaguely familiar with the 8 different types of licenses. For more information about these types of licenses, I suggest reading the regulations or going to my website and finding more information about it, or even just giving me a call or email. So, the background check process. Who must submit to a background check? Well, everyone seeking to license and operate a marijuana-related business must submit to a background check. Also, anyone and everyone seeking to work for, on behalf of, or volunteer for a marijuana-related business. What will be reviewed? Well, essentially any sort of negative history on a person's past will be reviewed. That includes criminal actions, anything to do with professional, occupational, or fraudulent practices, and also to do with any sort of professional license or registration. Also, the CORI record for every single person will be reviewed. This stands for Court-Ordered Request Inquiry. This is Massachusetts' form of a background check. Excuse me, how does the review process work? Well, first you must determine which of the 5 suitability standards to use. Yes, there's 5 suitability standards. I will go through them. Then, using those 5 suitability standards, you go through each part of someone's criminal history or background or negative history and determine what the result would be because of that event or background or history. And the 3 results are mandatory disqualification, because it's so bad, presumptive negative suitability, which is a possible, and I'll explain what that means, and 3, suitable for registration. Nothing is wrong with that event or piece of negative history. If the commission finds a presumptive negative, then a special committee will further review the record. I will go through what the committee does and how it works, but not right now. I'll go through that later on in this video. I'm first going to talk to you about the 5 suitability standards. And the 5 standards are for 1, licensees, retail and transport agents, 3 for manufacturer agents, 4 for cultivation or distributor agents, and 5 for laboratory agents. So depending on which uh, type of relationship somebody is seeking to have with a marijuana related business, whether it be retail or transporter agent or a licensee or manufacturer agent, would determine which suitability standard to use. Right here, I copied and pasted the first paragraph that came out of the draft regulation for suitability standard for a licensure. And essentially it says that anybody convicted of a felony, except for a marijuana offense or for a violation of 3494C, is prohibited from getting a license unless that offense involved distribution of controlled substance, including marijuana, to a minor. So I provided in this video uh, several slides that you can use, and I suggest pausing the video to determine which of the 3 results would happen because of one's criminal history or background or negative history. For licensure, I put 3 different slides. For the rest of them, 2, 3, 4, and 5, there's 1 slide for each one. So for licensure, if you look at this, you can see that for any open or unresolved criminal proceedings, there is a mandatory disqualification. And again, go through each one of these slides to determine which result would happen. Moving on to retail and transporter, you can see that there is not as high of a suitability standard required to that compared of a licensee, but still has some pretty strict requirements. Again, I suggest you pause the video to see if any of these apply. Here is the table for product manufacturer. Here is the table for cultivation and distribution. And lastly, here is the table for lab agent. So again, go through those 5 different tables. Licensure, unfortunately, is 3 slides long, and see what the result is. Moving right along, once again, the review process, that we must determine again the suitability standard, which are the 5 suitability standards to use, and then determine which of the 3 results happen because of someone's negative history. And then if there's a mandatory disqualification, obviously that person can't be a part of that aspect, or that is not suitable for that type of work. But if somebody gets a presumptive negative, then a special committee will further review the record. And as I mentioned, I would go through it later in the video, and here we are later in the video. So a trigger for a suitability review comes from a notification by people looking over, or investigative staff, of a need for review. And a presumptive negative suitability determination may issue if reliable information demonstrates that an applicant for licensure, or licensee, or a person seeking to be an agent of any other type of marijuana-related business that I listed earlier, resulted in the jeopardy to health, safety, or welfare of any person, or an applicant for licensure or licensee, or any agent seeking to work for any one of those 8 different types of businesses, are not consistent with public interest. So what does that mean? Well, I want you to take in mind the 4 different aspects here, and that is health, safety, welfare, or public interest. As long as the criminal history or event that resulted in a presumptive negative suitability determination does not have any indication that it put health, safety, welfare, or public interest in jeopardy, then the person should be fine. If the event or history or negative um, background suggests or implies or results in jeopardy to the health, safety, or welfare or public interest of somebody or of anything, um, then the person will probably not be able to pass the suitability standard. So, what is a suitability review committee? Well, it is appointed by the executive director of the commission for the purpose of considering whether an offense or information would result in a presumptive negative suitability determination, uh, and uh, to consider appeals from these determinations or mandatory disqualification. Now, a lot of people will fall into the presumptive negative suitability issue, and those people might be wondering, what will the suitability review committee look at? Well, they'll look at 10 things, and again, go look back at the regulations. They provide the list of these 10 things, or you can pause the video here and look at these 10 things. After the suitability committee reviews the record, it makes its determination of suitability, then it advises the executive director of their result, and then the executive director makes a recommendation to the full commission, the Cannabis Commission, which may or may not adopt the recommendation. In other words, the full commission has a final decision, and essentially the review committee provides the um, uh, advice that the executive director can use to when he's presenting his case to the full commission. So I hope that was helpful. I know there was a lot there, and I know it's very complicated. I tried to consolidate a lot of this into just a couple minutes. But if you have more questions, contact me. Here's my number. Here's my information. I offer a legal opinion of someone's suitability for 99 bucks, subject to change. And again, this video and everything said in it may not be relevant, and depending on the final regulations, might change. So without further ado, thank you so much, and good luck with everyone.